Okay, so let's just kind of dive in a teeny bit, and that is one of the things that I think is really important for us to look at is, and it's said a lot actually, real estate is local. We deal with our clients, our friends, our areas that we're familiar with, and rightly so. I mean, you need to know the areas where you're working. A lot of I just got back from CAR. A lot of what CAR does is based on the entire state, rightly so. So some of the concerns that they look at specifically, and I'm in professional standards and risk management. So when we have meetings, it's the entire state. Northern California does things a little bit differently than we do down here. Even Central California and LA, they do differently. They do things differently than we do. Not necessarily forms and things like that, but just procedures. So things that are of concern to them may or may not be of concern to you. So what we want to do is really kind of focus what we're training based on your local needs and your concerns. So one of the things that we're doing right now, we're going to do the RPA. Next, we're going to do the BRBC in the next class. After that, we're talking about which forms would be most useful. So if you have any suggestions or ideas or things that you've been struggling with that you'd really like to see a class on, throw it in a suggestion, throw it in the either you can use chat or you can use the Q&A. Whichever one you prefer, doesn't really matter to us. We'll gather that information and then we'll figure out. And it's probably 3 or 4 months away, but just so that you guys can get the information that's important to you right now. Okay. So what we're going to start with is the RPA. And for those of you who have been paying attention, you know that that did just change in the December release of forms. There's a couple of additional forms that were also released. The BRBC, of course, was left in place, but it was updated a teeny bit. And then how it connects with the RPA is one of the things that we will be going over today. So I think we're far enough along and we've got enough of the crowd in place that we can get started. So hang on just one sec. Okay. So what I've done here is I've pulled up, and I actually strongly suggest that you guys utilize this as a learning tool. The Forms Tutor on the CAR website, and I pulled it up because it has a really good big blown up version of the forms. But if you'll notice these little blue dots, they have kind of the legalese, the CAR explanation of what that is. So this will say, this is the joint escrow instructions. It's a document which details the buyer's offer. So it's very legalese. I'm going to do it a little bit more peopleese. But if you get stuck or if you have a question and you just kind of want to know a quick answer or wait, what was this again? You can go onto this form and click these little blue dots and it'll tell you what that little section means and how that relates to whatever you're doing should make it a little easier for you to make it a simple or fast answer, basically. So the very first thing that we're going to talk about is the date prepared. So a lot of people kind of don't pay attention to that. And the reason for that date prepared is because you can have a signature from a seller on one date, the signature from a buyer on another date. You can have additional forms, you can have addendums, you can have attachments that are all signed at different times. So this is the date that is always referred to when you are changing or modifying this contract in any way or any portion of this contract in any way. And this is the date that stays the same, basically. It's just a tool, if you will, for making it clarifying as to what form you're referring to. Obviously, the property address, that hasn't changed. Agency disclosure. So you have to have agency disclosure. We've all been familiar with that being attached. The one thing that I thought was kind of interesting that I got a question the other day, why is there a different form for sellers and one for buyers? Well, those forms are identical. They just will automatically attach an automatic autofill with the information depending on which one you select. So if you're representing the seller, it'll autofill for seller. If you're representing the buyer, it'll autofill for buyer. Um, I'm not sure why the form is named differently, but it is. But there is no difference in the form. The other thing that people get confused with is whether somebody is a dual agent. If you work for an office in Carlsbad and your compatriot in the same firm works in an office in Chula Vista, yes, you are still dual agents. Both the broker and the agent are technically dual agents. You have different representational agents, but you are still a dual agent for that broker because, as we all know, the broker is the responsible person for that contract. This section within the grid is the dates and the numbers and the things that are changeable in the form. This section of the form is the part that most agents focus on almost exclusively, which is okay, except that you need to understand how these relate to, you'll look over here where it says the paragraph, and then it has the specifics of that paragraph, and then you can go check those out if you have questions. You need to understand how those paragraphs relate to this grid. Purchase price, self-explanatory. Close of escrow, how many days, past acceptance, or on a date certain, obviously. Expiration of offer, all these things are very similar. Initial deposit amount. One thing that most people don't understand is that you do not need an initial deposit to create a contract. You need one to make the contract valid, in other words, close escrow on something. But an initial deposit is not required to make this a legal binding contract. You, for example, have VA loans where they have no money down, that kind of thing. The agreement will hold versus the amount of money. Now, you do need to, some escrows will require it to open escrow. There's a timeline for that, but just in case you have a question about that, that's one thing that I would discuss with both my broker and if you have any further questions with a real estate attorney. But basically, don't get too much in the weeds in that most people will just put $1,000, $2,000, $3,000, something like that, if that's required. The other thing that's interesting about deposits is the increased deposit. So a lot of people will put in an increased deposit upon, for example, removal of contingencies. That's great, but if you don't use the form, the IDA form, the increased deposit amount, that will not apply towards liquidated damages. And so you want to make sure that those are covered. If you have an additional deposit, that is also included in the liquidated damages. Loan amounts, again, self-explanatory. But the thing about loan amounts, by the way, is if you do not fill this information in, then they don't have the right to say that they didn't qualify for the loan that they asked for. If you don't have an amount in, that means any loan will do. So if they didn't get the loan they wanted and they've got one that's, 35% interest, that they do qualify for, technically, that would be not allowable as an excuse to cancel the contract should they not get the loan that they want. So always fill that out with the information that your clients are looking to do, are looking to create. The seller to credit to buyer. This is where we get into a little bit of confusion with a lot of agents as to what these actually mean. So G1, 3G1 is specific for closing costs. Any money that's notated in there is specifically for closing costs. Additional seller credit terms. We've had a lot of questions about that. So that can be anything from a credit for a roof or flooring, or the buyer or the seller took out the grandma's chandelier and the credit for the buyer to buy a new one, anything like that. Then 3G3, the one everyone loves, which is the seller agrees to pay buyer's broker out of the transaction proceeds, X amount, percentage of the final price, and a blank amount, or if checked, just a date, an amount certain. So that doesn't mean all of those have to be checked. You can just have a percentage. And there it's based on what you agreed to with your BRBC with your buyer. So if you've agreed to pay X, or your buyers agree to pay X amount, that's the amount that you put in there. If the buyer has agreed to pay X percentage, that's where you put that. You all understand that you cannot accept more than what you've agreed to in your BRBC. If you get compensation from another source, that will qualify towards whatever the buyer has agreed to pay on his BRBC. So any amount that you're paid based on the amount that you agreed to on the BRBC would be reflected here. So if you're deciding to ask the seller to pay for your buyer's compensation amount, this is where you would put it. This is where you negotiate it. You want to make sure you check the little box here. If you have any questions about what that means, again, paragraph 18A in the contract clarifies what that is. And we'll go through that in just a second here. In fact, maybe I could do it now. Let me pull up. I think it's in 2. No, I think it's in 3. No, it was 2. 18A, broker compensation, seller or buyer or both, as applicable, agree to pay compensation to broker as specified in a separate BRBC written agreement between broker and the seller or buyer. The amount of compensation, if a percentage, will be based on the final purchase price. Buyers advise that the buyer's broker should not receive compensation from any source in excess of the amount. And then I love this one. Third-party beneficiary. Seller acknowledges and agrees that the buyer's broker is the third-party beneficiary of this agreement and may pursue seller for damages or failure, to pay the amount specified in this agreement. So if your buyer agrees in his BRBC to compensate X amount and the seller agrees in the contract to do so and then doesn't, that technically the buyer is responsible because of his BRBC, but because the seller agreed, that makes him a third party to your agreement. It's like a really weirdly convoluted way of saying if that doesn't get covered, that you can still sue him. Oops, I don't know why that's there. Okay, back to here. So the verification of all cash obviously makes sense. The thing that's interesting to me is I don't know anybody that says that verification for all cash will be after acceptance. I don't understand how that would be in the benefit of a seller to have a buyer say, yeah, I got a ton of money, but I'm not going to show you until after you agree. Almost always it's going to be included with the offer, but it does allow, should there be some circumstance where that isn't plausible or acceptable or doable, whatever, that they would have 3 days, or you can fill in an amount of days after acceptance to provide that information. What that then gives the seller is the ability to give a notice to perform, which would then set in those series of legal requirements before you can cancel the contract. If you give it to them up front, that gives the seller the right to not accept a contract that is not acceptable based on the financial terms. He doesn't have enough money, or he doesn't look like he has enough, or what he gave you was a Mickey Mouse disclosure. That's his ability to sort of bypass that timeline and not take his property off the market necessarily for something that isn't provable. Then same applies to down payment, closing costs, and loan applications. The other thing about the loan applications is that there are 3 versions of that. That's become much more common to have. And that's obviously pre-qualification, which is, yeah, you look like you're alive. Pre-approval is, we looked at some of your stuff and it looks good. And if it is good, we're good. And then fully underwritten pre-approval is, we looked at all of your stuff and you have the money you said. So those 3 levels of approval should really kind of fit into your brain when you're negotiating, right? If you're in a highly competitive market, you're going to want to have the fully underwritten pre-approval. It is a lot like walking with cash. You've got your pre-approval. You're not going to have anything with the buyer that will kick this out necessarily. So you want to make sure that you have your ducks in a row, or your clients have their ducks in a row, as it were. You can be the duck wrangler. The final verification of condition. This is one that honestly, throughout time, I have seen again and again and again, people either ignore or it hangs them up. And I'm going to take a second here on this one because it's one of the things that people misunderstand. So let me see if I can find 16. Here we go. Final verification. Buyer shall have a right to make a final verification of the property condition within the time specified, not as a contingency. Everybody's aware of that, right? But solely to confirm that the property is maintained pursuant to the condition it was when you wrote the offer and that the repairs have been completed as agreed. What people don't often pay attention to, and oddly, it used to be below this paragraph, and now it's finally been above this paragraph since last year. Repairs. Repairs shall be completed prior to final verification of condition unless otherwise agreed. So we're going to close escrow and then we're going to fix the termite. We're going to close escrow and then we're going to repair the deck. If you have something like that in writing, that's good. If you don't, any repairs should be completed that have agreed to should be completed prior to the walkthrough. And it's a contractual obligation for the seller to give copies of invoices and paid receipts for any repairs repaired by others and a written statement of the repairs that they completed themselves. And they would give copies and invoices and paid receipts prior to the verification of condition. So prior to 5 days before close, your buyer should have in his hot little hands a pile of stuff related to any repairs that they requested. If that contractual obligation is not met, the response of the buyer is to give a notice of reform, ask for that before they do their walkthrough. There's a number of things that they can do contractually. But again, that is before they get to the final verification of condition. So those must be delivered so that your buyer has the ability to say, okay, yeah, this was done by, XYZ Electrical and that looks good. And then when they do the walkthrough, they have that stuff in front of them and they can go, oh yeah, it says here that they painted and it looks like they painted blue and the house is pink, but whatever, right? So you want to make sure you have that information so that your buyer can be as informed as possible when they go through the final walkthrough. The assignment request, here's another one that people don't understand very well, and that is that if a buyer, and this has ticked up recently because of investment buyers. So you have somebody that's going to, write an offer, he's going to purchase the property, and then within that first 17-day period, he says, all right, my buddy, Fred Jones and the Jones company is going to, he's going to step in and I'm going to give him my assignment of purchase, right? Your seller still has the right to approve that. They can't unreasonably withhold approval, but they don't have to just blanket say, yeah, sure, go ahead. The only one that's a blanket, sure, yeah, go ahead is, Fred Schmertz, and he'll assign it into the Fred Schmertz Trust. Or it could be an LLC, it could be a couple of other things, but basically it has to be the same name as the purchaser if that doesn't change. If they want to assign it to a completely different person, that has to be within 17 days, and that is a contingency. Not a contingency, it's a contractual obligation. So loans, they must give you their information, their approval within however many days. The standard is 17 or the base is 17. Same with appraisal. I'm sure we're all familiar, but I'll just go through it quickly again. If the appraisal comes in, you have a property for $1 million and you've agreed to, if it doesn't appraise for $1 million, you'll accept any difference up to 975. So that's where you would put 975. So if the appraisal comes in within 975 to $1 million, this is binding. If you don't put another number in here, it's the appraisal is the appraisal. The other thing about appraisals, by the way, is you are not obligated as a buyer to give a copy of an appraisal to a seller unless that is the reason you're canceling, or unless it's FHA or VA. Those two, and if that is the reason you are canceling, then you are obligated to give it to the seller. Investigation of property is 17 days, and then informational access to property. So again, people kind of don't understand this. So you have the ability to have an inspection on that property. You can go through and look at the systems and the electrical and have your physical inspector go in. You can have a roof and all the inspections you want, right? That's different than informational access. And sometimes those timelines are changed a little bit. I had a buyer whose wife was in Europe and she wasn't going to be back until after that 17 days was done. His big trigger thing was it had to be a week past that so she could come in and like measure for drapes and figure out where she was going to put her couch. So you would make sure that that is the timeline that you that gives them informational access to the property. This is not a right of cancellation. The informational access is just that, information. They're going to gather information. The investigation of the property and this as a contingency is based on the physical components of the property that you have checked out. Insurance become a huge issue in the state of California. The entire state is basically a high fire zone. That's something I recommend you start literally from the day you start looking and give your insurance broker addresses of properties that your clients are zeroing in on before or even concurrent with the writing of an offer. This can be a make or break for a lot of the properties. I've seen a number of properties fall because they could not get insurance. The seller is, I've had Fred over at the XYZ company for years and he's always been great. Well, Fred can't do it for the new guy. So make sure that you have that taken care of when you're writing the offer, especially as we move into summer. That summer and although our fire season is October, people seem to worry a little bit more about it then. A review of seller documents, again, same thing, however many days you can add. The one thing, again, people miss sometimes on this is if they get that information to their buyer on the 16th day, they have 5 days from that date. So that'll extend that time frame to the 5 days past whenever they get that document. And after that too. I mean, they just literally have 5 days from whatever you give them to review that information. And that, by the way, includes the buyer agent avid if he has anything that he wants to declare. Get those done when you write your offer or pretty close to that so that you can have that information or seller, excuse me, so that you can have that information to give to a buyer almost immediately because that removes that that stopping point to removal of contingency. Preliminary title report. Again, we're all familiar with these. Common interest disclosures. The other one is review of leased or liened items. This has become an issue, especially because of solar and water softeners and car plugins. Sometimes those are leased. There's just a myriad of things that can be included in that. Make sure that you are very familiar with what is on that property, what the client owns, and what they will have to provide information for. Time of possession, sale of buyer's property. Again, this is one we're familiar. COP is not changed really. Time of possession. This one has changed a little bit. It tweaked to upon notice of recordation or 6 p.m. or you can put a time. So a lot of people just leave it blank and say, okay, upon notice of recordation. That can be a little tricky because technically, if the property is recorded at 8 a.m., you're not going to be there with your trucks and your seller moving in and the other guy's moving out right at 8 a.m. and, bumping into each other in the hallways or whatever. So that can be something unless they're not going to be physically in place to move right into that property that you might want to change the timeline of because it does change their legal responsibility for the property. Once it's been recorded, it is the responsibility of the buyer. If you have a time of possession that's different than the date of recordation, then that will hold. So you would probably want to make sure that you are clear with your buyer as to what their comfort level is with that. Seller occupied or vacant units is if they're going to stay in that property, you all know SIP 29 days beyond 30 or more, it's going to be RLAS. That can create a tenant situation. So you want to make sure that you're very clear with your buyers about their responsibilities with regard to that. Occupied units by tenants or anyone other than seller. This is another one where people get hooked up a little bit. And that is if you have, for example, a home, John Mary Smith and their son Raymond, who is, 35 living in the basement, right? Raymond is a tenant and he has to have a TOPA on that property. If the wife is not on title, she needs a TOPA. Anybody that lives in that property that is not on title an adult, must have a TOPA. Because again, it clarifies the agreement with regard to tenancy. Seller delivery of documents 7 days is standard. Escrow instructions, when those are due, and it must be signed and sent back. So that's actually something that people have had a little bit of a problem with lately, and that is getting those escrow instructions back. We've had some of those drag out for quite a while. Contractually, that's a weird way to say it, contractually, you want to make sure that you have that within 5 days after the delivery of those forms to either the buyer or the seller. So you want to make sure that they're very clear that that's something they need to get back. Look through, arrange for signature, that kind of thing. Evidence of representative authority. So that's when you have a trust or an LLC or something like that. You want to make sure you have that paperwork. That signature page must match the name on the contract. If it does not, that's not the person that's signing. So you want to make sure that you have that clarified and that your buyer and or seller are aware that that is something that is required. This one is funny. I don't know why this strikes me as so funny, but it does. Uh, the items included and excluded, and the only one that's marked is a bathroom mirror. When they first came out with this, I was just sort of laughing, going, why is the bathroom mirror so important? But apparently, there was a rash of people taking mirrors off walls. So they had, the antique Lithuanian, gold leaf mirror in the bathroom, and they took it down and put up some, Home Depot janky thing, right? If you're going to do that before you put the property on the market. But this is the only one that's marked because that, again, was an issue. The rest of this stuff, obviously, you would have that based on whatever the property is. If you've got some broken out shell of a house, you're not going to include a stove, right? Or a refrigerator. If you are selling a regular, everybody used to live in it last week house, then yeah, that stuff's all going to be there. But again, washers and dryers, not necessarily. There's additional refrigerators, for example, in a lot of outdoor cooking areas. There's barbecues that are built in. There's refrigerators that are built in. You want to make sure you clarify that based, again, on the specifics of that property. Potted trees and shrubs. That's another thing I've actually seen people come to blows over. Especially the giant big pots that are really pretty and all that. So just make sure if there's an issue, you go through with your client, what's important to you, what do you want, what's going to make or break this deal. And you just have a clear expectation of what's going to be included or not included. Natural hazard zone disclosure report. There's been a lot of confusion about a secondary report, and it talks about it actually in this section as well, which is the secondary the other box, right? So you can include things that are in a drop-down menu that companies that are affiliated with CAR can provide, or if you have your names that you work with as well. That's the wildfire disclosure report. The optional wildfire disclosure report is just that, optional. It is not required. Do not let somebody tell you it is required. It may be requested, it may be something that they want to include, but it is not legally a requirement. The natural hazard zone disclosure that one will have additional options for environmental information. There's a lot of areas, for example, in San Diego that had buried gas tanks and gas pipes and things, which has been a disclosure issue for years and years. There's a lot of areas that have things that for example, the areas that used to be a dump. Uh, there's a number of areas that have things like that in their history, and so that would be something that would be of importance. Again, you need to know your areas that you work. Um, the optional wildfire disclosure report, again, that's optional. What it will do is it'll tell you what's nearby, and then what the cost, whether or not your property fits the clarifying requirements of the local authorities, and what the cost is to do that. Smoke alarms. Oh, and you can add additional reports, termite, things like that. Smoke alarms. By the way, termite reports, if you include it in a contract, is almost always going to be called out by a lender. So you want to keep that in mind when you ask, if and when you ask for that. Government required point of sale inspections and reports. Again, you need to know your areas. The only areas that require, by the way, the fire disclosure report require it as point of sale. There's, I believe, three entities in the state of California. Most of them are in Northern California. I'm going to guess there's probably going to be some more in LA. But at the moment, there's only three, and they're not in San Diego. Government requirement, point of sale, corrective or remedial actions. And you can put in here who's going to pay for any of those that are required. That can be things like, water heater, that kind of thing. Escrow fees. Most of us put each to pay their own fees. I'm not entirely sure why it's way over here, but and then you can name the escrow holder. Title, same thing. Buyer's lender's insurance policy. Again, that's something that people were not aware was a thing. And that is when a buyer has a loan, then the buyer's lender is going to require a title insurance policy tie-in. It's not a huge amount, but it is an amount. County transfer tax fees, all these things are pretty standard. Nothing's really changed. HOA fees for preparing disclosures. There's a huge pending lawsuit right now regarding HOA transfer fees, how much they can charge, what those fees can be for. There have been numbers up in the tens of thousands for somebody that has an everyday, it's just getting more and more expensive kind of thing. So this is something that is, it's been a question. So the seller has to pay for the preparing disclosures. The buyer has to pay for a certification fee. So for example, if you're buying in a condo and you have to have it certified to get a loan, that would be paid by the buyer. The transfer fees, you can negotiate this unless otherwise agreed. The seller pays for the move out fee, the buyer pays the move in fee. Those again are numbers that you're going to need to have a discussion with a homeowners association about, and have a discussion with your buyer and or seller about. Again, there's room for additional fees or costs. The other one is private transfer fees. That's one that a lot of people either overlook or don't realize exists. A number of communities, there's one, for example, Santa Luz has one. When a property transfers, they pay a certain percentage, and that fee goes to their community entertainment, community fee, and it pays for like fireworks on the 4th of July. It pays for the community picnic on Valentine's Day or whatever they decide to do. So there are fees that are sometimes in addition to standard fees that, again, need to know your community, need to know your neighborhood, understand what those fees and costs are. And that's where you would put that. So if you have somebody who's interested in an area that has something like that, you would want to clarify who is going to be responsible to pay that. It can get into some serious chunks. The one in Santa Luz, for example, can be, $20,000, $30,000. And that's not a fun surprise to have if you didn't look into it and delineate who was going to pay for it. Home warranty, again, up to your buyer and or seller if they want to pay for that. And again, the name of the company is blank, so you can fill it in. So then you get into the specifics of the additional forms. The thing about this contract is it is one contract. We used to have a separate contract for a manufactured home, a separate one for tenants in common, that kind of thing. So these now are addendums to the contract that create an additional level of contractual obligation with regard to whatever that form, whatever that is. So if they're buying a manufactured home, there's an additional form that they add to this contract. The other addenda covers things like short sales, court confirmation, if it's a probate sale, that kind of thing. You're going to have probate up here, but then you might need court confirmation down here. So again, depending on the contract itself, it can add different addendums. Buyer and seller advisory, the four that are automatically locked will be attached: fair housing, consumer privacy, buyer's investigation, wire fraud. And then if it applies, you can do things like trust advisory, REO, state buyer and seller advisory. This one most brokers recommend the statewide buyer and seller advisory, just because it's an additional layer of, hey, there's a bunch of stuff going on in your community. You might want to check it out. North County just completed a little bit last year a local area disclosure. We worked in conjunction with Pacific PSAR, and I think we worked with Orange County as well on some of the disclosures that we have locally. There's Coastal Commission, there's, as I mentioned, gas tanks, there's fire, there's a whole bunch of things that can apply to your transaction. This booklet gives information, it gives resources. Your clients can check, for example, the Water Safety Board. There's a whole informational page with links that they can utilize. And that one I very much strongly recommend you add as well. It's a CYA, but it's also informational, which I think is helpful. Additional terms, the initial deposit, the retention to deposits, all of these things you guys are very familiar with. If the buyer intends to occupy, this is one that's come up recently where people are checking that it's their personal property because it gives them a different lender rate. If they do not follow through with that, that's serious, but it's between them and their lender, essentially. Okay, hang on one second. It can create a tenant-owner relationship. I always assume 30 days or more with an RLAS automatically creates such a relationship. Yes, it does. Mindy, thank you for pointing that out. I said it can because most of the time the seller just wants to move. But if they decide, as we saw in the lovely 2000 times, they decide to stay, then that is a problem. Some of what's in that contract, the RLAS, does clarify and gives them a little bit of legal help, but no more than a standard lease contract, essentially, and people broke those all the time. So it's a risk, and it's a calculated risk, but yes, it can create, and it because it legally does create, but they don't generally utilize it that way, if that makes sense. The name of that last report you said, I'm not sure when you asked that question. Sorry, I didn't see that until until it was already there. Okay. The seller remaining in possession after close of escrow. So this is what we're talking about, actually, which is the RLAS. The parties are advised to consult with their insurance and legal advisors for information about liability and damage. And I very strongly recommend that you request that the sellers, if they remain in the property, have a rental insurance agreement so that the contents of their house and or the property are covered under that. We've actually had a situation where a seller remained in possession and then the house burned down. So they didn't own it, but all their stuff was in it. And now it's all gone. So there's just things that can happen that you don't even think about that could cause problems. And you want to make sure that the terms are very, very clear. Most of the time as a broker, I would recommend 29 days or less, just because it's simpler and cleaner. Although honestly, we've all seen everybody has seen probably at some point in their career somebody push the limits of that agreement. So there's no guarantees anywhere. There's no magic button. I always used to laugh and say, "There's no magic money button. There's no magic, fix this button." But it's better than not having anything. And the clearer you are with the understanding, and the clearer you are with the contract and the terms, and you don't write agent law, then the happier and the more successful the transaction is. I always say good fences make good neighbors, uh, because it keeps everything clear. Contingencies and removal of contingencies. The property not appraising at the purchase price doesn't give you the right to cancel if you've agreed to maybe a lesser purchase price, or if you've already removed that as a contingency. We saw a lot of that during the 2020 fun times again, where people were just waiving all of their contingencies up front, and then they couldn't qualify for the loan, or the property had a giant sinkhole in the living room, or something along those lines. If you've waived your contingencies, you've waived your contingencies. So you want to make sure that that is understood, and that your clients understand what it is that they're buying. Northern California does a little differently, and they used to do it much differently, where they would just give all of the disclosures up front and then require a buyer to remove those contingencies. When they gave all the information, here, review this before you write your offer, and then when you write your offer, remove all your contingencies with your offer. That has changed a teeny bit. They don't get quite that cut and dried anymore, mostly because they're probably half as many buyers as there were during the 2000s. But it's still a very different approach than we have down here. So sometimes you'll get a buyer or a seller from Northern California that approaches that a little bit differently. So again, be prepared to have that conversation about what that actually means, and what a contingency actually gives the right to do. Okay. The Fair Appraisal Act, that's a legal requirement. Read through it, it's fun. The investigation of the property. Again, we kind of went through this a little bit, and that is that the buyer has the right and the responsibility, really, to go through that property and determine whether it will suit his needs, right? And also that the condition of the property works for him. The seller is not required to move everything out of the house so he can see the walls, for example. Comes up a lot in garages, where they didn't see anything on the walls because there was so much stuff in the garage. It's probably the I don't know, second or third issue with regard to inspections, because the buyer says, "Well, I didn't see everything." Write that in. If you want to have them, if something is of concern to a buyer, make sure that you write in that the seller is to pull things back off the wall, to give access to the view of unimpeded view of the wall, for example, in the garage. Sometimes just moving the couch off of the wall or looking under a rug will show some things that you weren't expecting to see. So I would have that conversation. You're not going to be over there moving furniture and lifting rugs, but you want to have that conversation with your buyer and say, "Look, sometimes, we've seen some stuff that has, this house looks great, but, my son just bought one. The house looked great, but when they moved in, they found a whole bunch of stuff that was not readily noticeable, especially in the garage." So just be aware of that if that's of concern to your buyer. Have that conversation with the buyer before you look at properties, before you have that contract written. The other one that has really caused some problems is the buyer review of leased or liened items. And that's going to be solar in particular. There have been a huge percentage of buyers who had solar on the property. I have a listing right now where the buyer was unaware that the solar had not been removed. He was an out-of-area buyer and hadn't paid anything in over a year, and had gotten nothing from the solar company. The solar company went out of business, but the solar panels were still on the roof. It had been taken over by another company, and it just created this huge problem. There was a lien on the property. It was just a giant mess. So again, Make sure you understand what the agreement is. Make sure you understand who owns those, especially solar panels, but anything that's leased or liened. You've got water treatments, you've got security systems, you've got a bunch of issues that can be liened on the property. So make sure you understand those. The removal of contingencies or cancellation, there's timelines. And you have a specific timeline for almost every situation. So make sure if you have something coming up that falls within those timelines for removal or cancellation, understand that you are not able, for example, to give a uh, notice to buyer to perform more than 2 days before that item is required. So if they're supposed to remove contingencies on Thursday, you can't ask them to remove it the Friday prior, right? So it has to be within a 2-day timeline. Notice buyers and sellers don't understand the MLS, what the requirements of the MLS are, and if something is written in the MLS, whether or not it is included in the property. So if you have something that somebody has written in the MLS, for example, I don't know, you $10,000 for the roof. Unless you write that into the contract, even if you write all the stuff in the MLS, you have to specifically identify that item in the contract to make sure that it's included in the contract. Kind of makes sense. If you don't want to include something, for example, a seller has in the contract that, I don't know, the rugs are included at a price acceptable to seller or something silly like that, you want to make sure you exclude those in the contract if they are not indeed included. Anything that causes confusion, you want to make sure you remove. That has been a problem too, by the way, with staging items, items that are staged. And I'm going to kind of briefly segue out for 1 second, and that is photos. So photos on the MLS, if you have a staged property, either virtually or real staged, you need to make sure that it's clarified that that is a staged property, especially the photos. We've had some issues with, for example, somebody puts a fire in a fireplace, but the fireplace isn't actually workable. You have somebody that put a sunset in a sky in a direction that the sun doesn't set. You have people that showed, oh, look, this is what the property can look like painted, but didn't clarify that on the photo. And so the buyer shows up and the house is pink and it's not black or, gray, whatever. So just make sure that if it is changed at all, that you clarify that on the contract. And let's go to 2 here. Okay. So then you have the timeframes that we discussed about the ability to cancel and the contingency removal. And when it comes time to cancellation, a lot of times people will give, for example, a buyer notice to perform and say, all right, Mr. Buyer, you haven't given me any, the loan information, or you haven't given me your removal of contingencies. And so, I'm giving you a notice to cancellation. If the buyer agrees, or excuse me, cooperates with that requirement, the seller cannot then still cancel. A lot of people don't understand how that form actually works. Gives him the right to cancel if the buyer doesn't cooperate, but if he does, you're still back in contract. So you want to make sure that if you give a notice to perform, that your seller and or buyer understand exactly what that means and what rights that gives them. And then the removal of their contingencies, we kind of went over that already. The removal of seller contingencies, the demand to close escrow. So that's an interesting one. We've had a number of times where escrows have been delayed quite a lot longer than 3 days. If both buyer and seller agree and nobody does anything differently, then that timeline just continues until and unless somebody does something that changes that. The question on the MLS was, when notating it's staged or virtual, does this go in public remarks or confidential remarks? It goes right on the photo. So you can write onto the photo, underneath, when you add the photos up, there's a space below for a description, and you can put that on there and that'll show up in the photo itself. When they click on that photo, it'll say what it is. You can also watermark them. I've had that suggested for specifically virtual staging, so that it's clear that this is a staged property. The MLS also requires, at least CRMLS does, and most of them are following the same rules because it's a law versus an MLS rule, but or a civil code, excuse me, versus an MLS rule. Those two must be next to each other. So if you have a blank photo or a staged photo of the property, next to it has to be the blank one or the one without the staging, right? So you can see, here's what it looks like staged, here's what it looks like not staged. Again, it's to remove confusion in the eyes of a consumer or a buyer. By the way, just while we're on the MLS thing real quick, CRLS just changed, and I believe San Diego is going to go the same way, essentially. When a property is marked pending, sold, expired, or canceled, the photos are sealed. They cannot be changed. And so they're also being taken off of the IDX feed. So any property that's out there that has, a lot of times buyers are requesting that all their photos be removed. And the MLS actually owns those photos. And the photos are helpful and are required to be retained for 3 years by statute again. But the MLS can retain them in-house. So you only can see those photos if you're an MLS subscriber. So appraisers, agents, and any IDX feeds that go out there will only have the main, the front of the house photo. Representative photo, I think they call it. They don't require that it should be the front of the house, but sometimes it's like an overhead, or there's different requirements for that. So just so you know, that's a rule that's changed, and it's been a statute. It's been a requirement of the state for a while, but this is how they're implementing it. Okay. Repairs, again, we went through that, but again, please note that those repairs should be given as receipts and or a written statement if the seller did them. With receipts, Home Depot, they got the wood there or whatever, and copies and invoices prior to the final verification of condition. So if day 6 or 7 before the close of escrow, you haven't gotten those, I would be requesting them and pointing out paragraph 15 of the contract specifically states that they must be given to them before the final verification of condition. Broker compensation, everyone's favorite topic. Based on the purchase price. I'm not clear why we have to say that, but I guess it makes sense that we have to say that. It's based on the final purchase price, whatever that is. Third-party beneficiaries, we went over that briefly. Scope of duty. So again, these are things that you should be going through with your clients about what you're required to do, what they're required to do. Escrow instructions. This contract, a number of years, probably 10 years, maybe 15, turned into escrow instructions as well. Escrow will have additional instructions, but essentially, rather than rewriting the entire contract, the contract is now also escrow instructions. So just so we're clear on that, it is to remove discrepancies. They'll get the general provisions from escrow and then any additional specifics. Tax withholding, all that stuff that goes through escrow, that's in here as well. Broker compensation, how the payment is disclosed. Everyone knows you have to be a broker to receive payment or through a broker. Invoices can be given to escrow. It has to be very specific amounts. Delivery of amendments, when those are to be delivered. If there's an amendment that is being made, that can be a separate item from escrow after agreed upon by buyer and seller. Leased or liened items, we don't always have control over those, but the time specified in the contract is what should hold. If somebody wants to cancel based on that, they would have to give a notice to perform. Items excluded from sale, again, great on Egna's, chandelier or her rug. You want to make sure they're taken out. Who pays for the inspections, the government requirements, the home warranty, all of that stuff is in the contract and clarified as to who's going to pay them. This gives a little bit more in-depth description of what those items are. A lot of clients ask, what is an NHD? What is the TDS? What is all that stuff? And that's actually in here, and it does give a fairly clear, comprehensive description of what that is. And the event of any other questions, if you have an addition, this is one that's kind of interesting to me because I had it come up recently. If you have a seller TDS that they've delivered, the buyer's agreed and removed that as a contingency, so the condition of the property contingency has been removed. Then when the buyer is going through the house, they find, a sinkhole in the living room, right? That's not a contingency. They've removed the contingencies. It's not a new material fact if it's discovered by the buyer after they've removed contingencies. So you want to make sure they have done a very thorough check of that property. If the seller amends his disclosure or the seller finds this sinkhole in the living room and gives that information to the buyer, it is a contingency removal, 5-day timeline. Lead disclosures, not a big problem in California. Home hardening, fire hardening is a big problem. We've had a lot of questions, by the way, about that zero zone. Zero zone is discussed. It's been confused with the fire hardening defensible space. It does not yet exist. It hasn't even been written yet. It's one of the things that is very much misunderstood. When it gets written, it will have to be reviewed and then approved and then put into statute and then implemented. So we're probably 3 or 4 years, probably 4 years away from having that be an issue. But the zero fire zone is from your house to 5 feet away, I believe, has to have zero burning items in it, right? So all the little wood chips everyone loves, that kind of stuff, those are all fire starters. It'll be interesting to see how that gets resolved, but as I said, right now it hasn't even been written. The defensible space disclosure, we just went through. Electrical system inspection advice disclosure, that has occurred because of so many issues with failing electrical systems, older houses, boxes that were recalled, just so much involved with electrical that they literally just created a whole new disclosure based on, yeah, guys, this can be a little sketch, so check it out. And that's kind of basically what it says. It's really sketch. Have somebody look at it. Waiver of statutory lead or other disclosures are prohibited by law. So you cannot say, I don't care about lead. Termination of rights, if any disclosure is amended is delivered to buyer after the offer is signed, the buyer shall have the right to terminate this agreement within 3 days, in person or 5 days after delivery in mail. That one always cracks me up. Nobody goes around with their little paperwork in their hand handing it to people anymore, right? So almost never are you going to see that 3-day thing. It's almost always going to be 5 days. The email address that you put in the contract at the bottom when we sign it, and I'll go through that in a second when we get there, that's the address that is legally acceptable for the delivery of information. So that 5 days starts from when that information gets to that email address. And hopefully that stops the, I didn't see it, I didn't get it, the dog ate my homework stuff, right? That's the address that you gave me. That's the address I use. That's considered delivery. The rest of this is pretty standard. Natural environmental hazards. Again, a lot of this is based on the fact that the entire state is really a fire zone. So we have to make sure that we have clear, understandable timelines for the delivery of that information. But the natural hazards, natural environmental hazards, that booklet doesn't just cover fire. It also covers things like, I think I mentioned before, the buried gas tanks, the issues with former dumps, methane gas. There's just a number of things that can be included in that, and that will identify those items. The thing people tend to, immediately go to is the fire, but it's not the only one. So pay attention to the other ones as well. And again, know your areas, understand which areas have issues. For example, I never realized that in that valley between Santa Luz and Escondido, there is a whole development that was built over a section of land that was originally a dump, oh gosh, a long, long time ago. And it actually had some methane gas issues. So you want to make sure you understand community. You want to make sure you understand neighborhoods. You want to understand the requirements of those areas. I mentioned in passing, if you have an area where they have, for example, septic, the requirements for septic are very, very different based on the area. If you have an area that's very rocky, for example, you need a much larger piece of property than you do somewhere that's smaller. People in Carlsbad are probably not going to run across many septic tanks in downtown Carlsbad or Del Mar. Valley Center, Rancho Santa Fe, yeah, a little more likely. So again, know your area. Solar systems, I've mentioned this a couple times. It's been a continuing issue that comes up again and again and again with the solar power systems and companies that have gone bankrupt, companies that were taking over for the companies that went bankrupt, what those companies actually cover, what they require. So make sure you have a copy of the contract if they signed one. If they have a lease, that you have a timeline for when that lease is up and if there's any monies due. And if the company went bankrupt, like a number of them did, who is now taking over that, and whether or not there's a lien and that kind of thing on the property. Known material facts, they're required to disclose them. I think that's pretty standard. Buyer's investigation, again, really understand this. I would strongly recommend that each buyer essentially go through this with their, or buyer's agent, excuse me, go through this with their buyer and say, look, here are all the things, and let's just, take this paragraph and go through it and explain to you what your requirements are as a buyer and what you should do when you're looking at this property. A lot of times a buyer will go through and, oh, what do you think? What should I do here? What should I do there? It's not my house, your house. I want you to make sure that you have a clear understanding of what it is that you're buying. I've always recommended, I've actually given my buyers a pad with little check marks and things on it that CAR has a page that has, things that are important to me, basically. And then a pad for them to go through each of those properties and determine how that fits with their requirements. Like, it has this, but it doesn't have this. I really wanted a pool, but it has a gazebo. And, I like the hot tub, but I don't like the sauna. That's the kind of thing that you want them to clarify for themselves. The buyer indemnify and seller protection for the entry upon the property. So you can't walk onto the property as a buyer, you're like, I'm going to buy this house, and then trip and fall and then sue the guy. I don't know. I think that kind of makes sense, but you never know. I don't think it was really ever a problem. It might have been at some point, but that's what that does. Title is taken in its present condition and subject to all encumbrances, easements, covenants, conditions, restrictions, rights, and other matters. We've had a number of issues recently where there was, for one example, a person passed away, the successor trustee had the property on the market, and an heir decided to challenge, right? So now there's a cloud on title. Title can choose to bond around it, wait for it to be cleared, or just basically close with it still in place. That's something that Most of them are not going to do the close with an in place, but sometimes they'll bond around it. I've seen that a number of times. Again, you need to have your client speak to a real estate attorney. That's not something we can talk to them about it because it's a title thing, or have them talk to their title officer. Sometimes they can give them clarity that you can't. But that's a kind of an interesting point if it comes up. So make sure you have that discussion with your broker as well. Federal reporting requirements. This one is so interesting to me. Geographic targeting order. So they just expanded this. It's aimed at drug trafficking money. So I think it's kind of an odd honor to be included in the area they think is drug trafficking. But that's part of that. If you have a foreign investment buyer, or if you have a property that's sold without a loan. So if you're selling an all cash property, they're going to want to look into where that money came from. Deed investing, title insurance policy, time removal, contingencies. All of these are pretty standard. Nothing really has changed on these. Seller's right to cancel. This gives that timeline that we've talked about. And this is one of the ones that's kind of interesting to me because a lot of times people don't understand. They understand the buyer's right to cancel a lot, but they don't understand the seller's right to cancel. So the seller, once he's delivered all of his information to the buyer, kind of has to wait for the buyer to remove all his contingencies. And if the buyer removes all of his contingencies, the seller really doesn't have a whole lot of reason to cancel. If he gets what he wants and the buyer performs, he can't go, you know what, this guy's not the right color blue today, I'm changing my mind. It is not a particularly flexible cancellation policy. The buyer has the right to cancel if the seller doesn't do what they're supposed to do, doesn't deliver their information that they were supposed to deliver, or if the property doesn't suit. All of that should be removed in that 17-day or longer or shorter, depending on what you wrote it into the contract, part of the contract. If the seller doesn't give the information or do the repairs as he was requested, there's not a whole lot else, but yeah, I mean, there's details that we've all seen in contracts, but basically the buyer has a few more things that they can say, yeah, it's not working for me, and get out. But once they've performed based on that contract, there's not a whole lot of wiggle. And most people forget this is a binding contract. So make sure that the forms and all of the things that are important to your buyer and or seller are included in that contract, because it's very difficult to remove it or change it after the fact. The removal of buyer contingencies, again, we went through that sort of closely. The demand to close escrow, again, timelines based on what's going on in the contract itself. And then if it does cancel, what happens to that deposit? So this is another one that a lot of time people don't understand, and that a release of funds requires mutual signed release instructions from the parties. And you can get a party may be subject to a civil penalty of up to $1,000 for a refusal to sign cancellation instructions. But basically, if you want to cancel, then you need to get signatures on both sides to release that money. That is one of the things that people go through court a lot, or mediations a lot, is that they feel like they are owed money for their time, or they're owed money for repairs that they made, or something like that. Again, that's something that we cannot really necessarily resolve. Almost always it's going to have to be between the buyer and seller and a legal dispute. So you want to, make sure you have a valued real estate attorney that you work with. The final verification of condition, I mentioned that a couple of times. I'm just going to say it again. It's not a contingency of the sale, but when they get to that point, you make sure that you have examples or copies, of the receipts for the work that has been done, so that the buyer can see that work, not only physically he can look at it and see that it's been done, but that he has a receipt for, if there was electrical, for example, he has the name of the electrician that did the work, right? I think it's a save thing for the buyer and the seller. We went through broker compensation already. Page 6, okay. Joint escrow instructions, escrow holder, we went through that. Copy statements of tax withholding instructions. So that's that form that the qualified substitute form that you get from escrow. That's what that is. It's specific to trying to keep the money in the country for the sale of a property, if they have, or taxes basically in the country. Verification of deposit, delivery of amendments, all of that stuff is timeline. Trying to get through this so we can have some questions. Leased or liened, we went through that. A lot of that is escrow. Solar. Inspections, reports, tests, and certificates. Again, I clarified with regard to if you have an appraisal, you have to. The seller is entitled to a copy of that appraisal if you cancel for the appraisal. Otherwise, they are not. Everything else you have to give a copy of to the seller. If you had an inspection report done, you need to give that to the seller. If you had, termite, if you had solar, electric, whatever, any of those inspections should be given to the seller. Home warranty plan, that one is not statutory, so it is not required to be given to a seller. TDS and other statutory and supplemental disclosures, those are all part of disclosure. They should already be given to both parties. Anything else? Home warranty, dispensable space, addendum, electrical system, all of that stuff. And then let's go to there we go. Liquidated damages. If you are initialing liquidated damages, that is a decision made by the buyer and seller. That's why it's in a little box. That's not something that'll be auto-filled by the signing program. And that limits the exposure of the parties to 3% of the purchase price or the actual deposit, whichever is less. Unless they haven't signed the liquidated damages clause, in which case you just duke it out. Mediation, this is an automatic, and it's not even signatured, it's just you agree. If you have a problem, you agree to mediate. Arbitration is a different deal. Arbitration is specific to a legal agreement. Again, suggest that they read that carefully and or discuss it with an attorney, because it limits their ability to go after the seller or buyer in a lawsuit. The expiration of offer is 3 days unless it's extended. Entity buyers, again, that's LLC, probate, partnership, etc. If that's the case, you put the entity name. We all know this. The RPA has 17 pages. Make sure you've read all of them. I like that they have to say it a bunch of times. I think it says it at the bottom of the pages too. Just in case you weren't paying attention, it's 17 pages. Names, signatures, all of this. Then this is kind of interesting, and this is added, and I like it. If the seller, hopefully we get back to these days, has multiple offers, you can have a counter offer that you add, you give them as your response. You can accept it, or you can put them in a backup offer position. Entity sellers, here's where they sign. Again, this is RPA is 17 pages. Then you have seller signatures. The real estate broker section. This part is where you're going to put the email. So the designated electronic delivery address email is here, or if you want a different one, here. So if you're using, CZQ sells for you, and that's your email, but you want the contract to go to your broker, your TC, a specific file that you've created for this form or for this contract, that's where you would put this, right? So this is the legally acceptable, if it's sent to this address, it's delivered email address, right? What this does is it removes ambiguity of delivery. It's an important item to use because it keeps you from saying, well, again, the dog ate my homework, that kind of thing. If the parties elect to have an alternate delivery method, Wandering Cats, Pony Express, you would form the DEDA and utilize that. So it could be, everything goes through a certain address or a certain person. It's all going to go through escrow. Some Northern California agents have a specific address created by escrow that all of the forms go through. That's the one that would be utilized by. There's some people use the form in zip form that creates a workplace for them to utilize. If you want to use something different, most people just use their email address simply because it's easier for everyone to realize. I will give you one tiny little tip though, and that is when you are opening an escrow or working with a buyer or seller, have them star your address and the address of escrow and or title, anybody with, and their lender, anything with access to any financial information or information on this contract, have them create a file for them in their email with a star on it. When that address comes back, if it does not have the star, it's not them. And there's a lot of fraud where the fraudsters are using acrylic address or uh, um, letters. That's the word. And they look just like the original, but they're not. They're not the same. It's just a slightly different form. So if you create an email address that has a specific denotation on it for that file, it will only show up with that star on it or whatever you've put on it. And that'll help when you get a file to say, oh, is this really from this person? Okay, so obviously from here on out, it's escrow holder acknowledgements. Here's the other thing where people are having real issues with not understanding, which is that the presentation of the offer, the seller's brokerage firm presented this offer on X date. This is all you can ask for. So if you don't think that, Agent Aaron is presenting your offer, you can ask him to give you this form signed. That's all you can ask for. You cannot ask for anything signed by a seller. And you can't ask to see it or anything like that. You can ask for this. It's sometimes you'll get back the no counter offers being made, offer wasn't accepted. But most often they're just going to get the presentation from the offer. It was presented on this date. Okay, now we have a minute. Anybody have any questions? Well, we have 10 minutes. Okay, there's just a little zippy over here. Let me look. Oh, back in the beginning. Sorry, yes. Do you have to agree to an assignment request? No. The seller has the right to say no, but, and again, this is where it kind of gets into a little bit of a legal question. They can't reasonably withhold approval, right? So what does reasonably withhold mean? I mean, um, if somebody is buying it all cash and the person who they want to assign it to doesn't have any information about their cash, yeah, that's reasonable. If they have a bunch of cash, but you don't like them, or you don't want to sell to a company or something like that, you can't reasonably withhold based on anything other than a very specific set of uh, requirements. TOPA is the tenant in possession. And that is if you have, for example, mom and dad live in a property and their 35-year-old son lives with them, or they have a caretaker with them, or even if the wife is not on title, they have to have a TOPA form signed, which essentially says that they're a tenant in that property and will be until the close of escrow, and then at which time they'll move out. So even though they don't technically, or what we consider to be tenant, they are technically, on the terms of the contract, they are a tenant. So anybody living in that property who is not on title is a tenant, must have a TOPA. What did you mean by star in the email? In email, there's the ability to mark your regularly spoken with people, and then that you can put a little star by their name. So when it comes up, it shows the star in the contract. That's something maybe that there's a number of forms, and maybe that's actually one we could do. Shirley, make a note of that. The had little tricks on email to how to make it easier for agents and for them to talk to their clients about how to do this kind of stuff to make it simpler for them to maybe avoid some of the fraud that's out there. You mentioned that if the listing agent and selling agent are in the same brokerage, a dual agency exists. Do the listing agent and the selling agent check the box of representing seller or representing buyer? Have to check the dual agency box or representing both parties. It will automatically, the form itself, zip form, will automatically, because your broker is going to be the same broker, so it's going to automatically check the agents of both office of dual agent box for both parties. Please explain more for the trust. Explain what for the trust? That can you expand on that a teeny bit? What you want answered about the trust? Okay, so Lynn Ramskill, I'm guessing that you got it answered. So if there are no more questions, wow, we made it with 6 minutes to spare, guys. This is awesome. So now I just do want to say, if you have had any issues with contracts or stuff that's come up, we're going to do our next class in the BRBC. And then what stuff is bugging you? What stuff happens here? I've just gotten back from CAR, so a lot of what we discuss is stuff that goes on up and down the state. It's going to be different in Northern California than in LA than it is here. So what issues are you having specific to your projects or your clients here? We've seen a lot of the vacant land fraud. We've seen a lot of the problems with solar. We've seen a lot of issues with stuff that is very specific to us, coastal commission stuff, that kind of stuff. Anything that you have that's been an issue, let's talk about stuff that really matters to us locally. Okay, so one question. What happens if the seller is an investor and is not cooperating to give invoices for repairs? How many days can you hold escrow for? Or how can we pressure him? Well, that's a demand to perform. It's a demand for seller to perform. You would give him a notification to perform. Then if he doesn't, your options are really the same as if he gives a buyer a demand to perform on a contractual obligation on the other side, and that is they can either cancel or the buyer can perform. So it really is a matter of how motivated is that seller to sell. But that's the pressure is that demand to perform. All right, everybody, you have been awesome. And I appreciate that. Anybody have any questions or concerns or have an issue that they want to have discussed in one of these classes, please send us an email, especially to Shirley, and we will get something on. I'd really like to have somewhere we have a little more interaction. I mean, I just feel like I'm just sort of word vomiting on you guys. And if we have some, that would be great to have, where you guys have some questions about stuff that's going on currently. I know that our areas are very specific to the areas that we work. And sometimes those they get down into the kind of the nitty gritty about weird stuff that happens. So I'd really like to, I think that helps all of us to have some additional information. All right, guys, thank you very much. This has been wonderful.
Thank you, Nancy. Tracy.
Hey guys.